all of our distinguished speakers. However, first of all, I would like to extend my greetings to our Indian partners and to congratulate you all in the name of, from all of us here in Russia, with the recent celebrations, with the Independence Day. And we really wish all the best prosperity and social progress to our country. And of course, we hope to have a very fruitful collaboration with you in the future. So I will now introduce our speakers. We have Batyr Dzhankezov, who is an assistant professor of constitutional law at Synergy University, namely its branch in Cherkassk, in Karachay-Cherkessia. Not all of us here are from Moscow. I think this is a very positive development. We have to really, be able to encompass all of the vast geography of our country. Next, we have Yuri Cornosa, who is a graduate of the Higher School of Economics in Russia, one of the best, most international universities of Russia. You might probably know. We have Pavel Kulakov, who is a master's student of Higher School of Economics as well in the program of History, Theory, and Philosophy of Law. And on the Indian side, we have Siddhant Sijoria, who is a Master of Laws, a graduate of the CEU University, and currently he is a practicing advocate at the Supreme Court of India. We also have Nitish Rai Parwani, who is another co-founder of this forum, and who is a legal researcher at the Supreme Court of India as well. So these are all of our speakers, and we will start with the Russian side of the story. I will now ask Pavel Kulakov and Yuri Cornosov to introduce the history, the background of the creation of the Russian Constitution and its current outline as it is. Please, the floor is yours.
Thank you so much, Marina. I think that Yuri can be started. So, I'd like to pay him attention.
Nice to hear you all. My name is Yuri Cornosa. So I would like to tell you about the background and the current state of the Russian Constitution. To begin with, the Russian Constitution almost perfectly fits into the requirements of democracy and the rule of law. On the contrary, our current political regime is actually an autocracy, but the Constitution provides a respectable democratic facade for this. It appears that the Russian Constitution is not rooted in our Soviet past. The political system of the Soviet Union established a single party system, a dominant communist ideology, a legal framework for a totalitarian regime. All these above-mentioned elements are not now in our current constitution. Now, the constitution provides for separation of powers, checks and balances, protection of human rights, legal framework for free market. Overall, it corresponds with universal values of democracy in the form that we can see all over the world and mostly in Western countries. Our economy now is fully capitalistic, not socialist. So our constitution corresponds with our political reality here. It's about our Soviet past and how our constitution has been written. Actually, the creation of our constitution was a result of a political conflict between the president and the parliament when after the fall of communism, Russia went great political and economic transformation in 1990s. The president dissolved the parliament, although he did not have such powers. So the parliament tried to have the president unseated, and the constitutional court approved this impeachment, but the president simply dissolved the parliament and had a referendum approved his version of constitution. And his version was created, for sure, to ensure the great power of the president. The nearest sample is the French Constitution, the Constitution of the French Fifth Republic, that provides a presidential republic. We have something like that. But our Constitution, for example, made it practically impossible to unseat the president, to have them him or her impeached, and to dissolve the government if the parliament wanted to do so. This maybe authoritarian tendencies rooted in our constitution then helped our next president, Vladimir Putin, to consolidate all the power in our political system and to build a fully authoritarian regime. Then, in 1990s, Russia was so-called flawed democracy with some authoritarian tendencies, but with the strong degree of political competitiveness and so on. This democratic facade remained almost the same during the 20 years of Vladimir Putin's rule. There were few amendments to constitution. The most significant of them were the enlargement of president's term from 4 years to 6 years. And this year, the Russian president has his new amendments approved by referendum in 1st of July this year. There is a great number.
What are you for?
Sorry?
Could you repeat your question, please? Because it's loud.
Excuse me, I would kindly ask you to write your questions in the chat, and we will later take them. Okay?
Mm-hmm. Yeah,
Pavel,
Yuri will be happy to answer all your questions after his speech. So I think he has about some minutes to finish it, and then we'll be happy to answer your questions. Yeah.
Current amendments I was speaking about further improved and strengthened president powers, and but the core of constitution remained democratic and corresponding with universal values of democracy, of human rights, and so to summarize, I would like to emphasize that our constitution, unlike our political regime, is quite democratic. It provides a good framework for free market, for capitalist environment of our economy, and so on. So it, in many ways, does not correspond with our political reality.
Thank you. Thank you very much, Yuri. I will now pass the floor to Batyr. Before that, I would like to mention that we are going to have a Q&A session separately, either in between the Russian and the Indian blogs, or at the very end, depending on how, depending on the timing. So I would now like to ask Batyr Dzhankezov to join and to give his reflections on this same topic. Thank you.
Thank you, Madina. What about my presentation? Is it seen? Can you see my presentation?
As of now, no. Do you share your screen?
I believe I did. Just a second, please. Ага.
Показать на главном экране, там кнопка справа внизу.
Ага, я ее нажал, но... Ага, окей. Окей. What about now?
Okay, yes, it's starting to be visible.
Okay, good evening, ladies and gentlemen. I would like to...
Good evening, sir.
I'm going to present different stages of evolution Russian constitution, Russian constitutionalism, and...
Sir, we are studying Indian constitution, but how come you're teaching us Russian constitution?
I'm sorry. I would like again to please ask all of the participants
We are
to
from
remain
India, sir, but then you are teaching us Russian constitution. How come, sir?
to remain silent. Okay, but please continue.
Okay. In Russian constitutional law science, many scholars divide our constitutional history in main three parts: before the October Revolution, before the Soviet period of Russian history, Soviet period of Russian history, and the present time. And of course, all of these parts can be divided in other parts, but in mainly we speaking about the three main stages of Russian constitutional process. Okay. And about the constitutional development of Russia, first of all, I would like to point that the question, what is the very first constitution of Russia, is not so simple to ask, because a lot of scholars thought that Imperial Manifesto from the 17th of October 1905 about on improvement of public order can be described as a legal act with constitutional character, but in strict sense of this word as a constitutional, of course, we're speaking about the constitutional of Russian Soviet Federative Socialist Republic from 1918. As you can see, the Russian constitutional history mainly starts in 20th century. You can see the three major legal acts which prepared very broad basic of Russian constitutionalism in whole European legal roots, but after the communist revolution we choose the other way, and it was a way of Soviet statehood with common property, so on and so forth. And the other idea was that at this Soviet period of Russian constitutional development, Russia wasn't an independent state, but it was a part of the biggest state of Soviet Union. So in Russian constitutional law, when we studied the constitutional development, we mentioned not only the constitution of Russia, but the constitution of Soviet Union. And since the 1924, you can see that after the adoption of Soviet constitution, just from 1 year was adopted the constitution of Russia, of Russian Federation, and the latest, the present Russian constitution, was adopted in 1993, and we was celebrated in December 25th anniversary of our constitution. And I would like to repeat the idea: what is constitution, what is Russian constitution, is what is the very first of Russian constitution. One of the famous Russian scientists said that if this law was the basic law of Russian Empire, but not constitution. But they has different legal force as a ordinary law, and a number of scientists regarded these basic laws as the Russian constitutional in whole or in part. And in 1920s, the famous Russian scientist, constitutional scholars Vladislav Durdinevsky called them the very moderate constitution of an individualistic type with elements of imitation of the text of Prussia and Japan. About the Russian constitution, we already hear some specifics of our constitution. You can see that our constitution is not big, just 136 articles, 9 chapters, especially in comparison with the Indian constitution. And I would like to point your attention to the fact that our different parts of our constitution has, first of all, different legal protection mechanism and legal judicial power. For example, the first chapter, the fundamentals of the constitutional system, there is the constitution inside the constitution, the core of our legal act, because none of the other parts of our constitution can be contradict to the first chapter of Russian constitution. And in chapter 9, has the legal protection mechanism for the 3 chapters, the first, the second, and the 9th. They can be includes amendments. They can be only reviewed, which mean we vote for the new constitution. And about just a few words about the historical and political background of the adoption of our current constitution. I think the very important 3 points was that the constitution must to decide very important task. First of all, it was a situation of dissolution of Soviet Union, which President Vladimir Putin named the largest geopolitical catastrophe of the 20th century. The second of all, in 1993, just before the adoption of constitution, Russia was at the very big political crisis, and you can see that the crisis between the tension between president and parliament, high council, which you named at this time, was not only in political but also in warfare terms. And the third part, that Constitution of 1993 must to create very new basic ground of the political and legal foundations, because all previous 2000 years history of Russia was in different political, economical, social, even in cultural circumstances, and the idea to build democratic, legal, federal state was very complicated, even in these historical circumstances. And I think that our constitutional, especially if we are talking about not only judicial terms, but as a real law which influence in every part of our country, is not perfect, but I believe that all of these 3 tasks our constitution fulfill, maybe not so effective, but still. And about some institutional disbalance of our constitution. Many scholars says, also Pavel mentioned, that our constitution consists from, if we can say that, consist on 2 parts, so-called liberal part and so-called authoritarian part. The liberal part, it was the first 2 chapters, the first and the second, about our fundamentals of constitutional system and human rights. Human rights also mentioned in previous Soviet constitution, but it was not so democratic ways, and of course it's not implemented in real life. The founders of current Russian constitution, using more advanced constitutional technologies from international law, from the United Nations Charter and other sources of international law as for Constitution of India, but the legal mechanism of political struggle for power between different branch of power, between government, between parliament, between president, wasn't so democratic. The check and balances system in Russia not fulfill their goal, because the president not only the core of our political system, but has much more power than other three branches of government. And it's very unique situation in Russia when president is not a part of executive branch of power. And a few words about the nature of our constitution. You can see the three different approach, all of them very interesting, and we can discuss every part of them. And I believe that mm, every this approach can exist and describe different parts of our constitution. It's very complicated history, complicated structure, and so on and so forth. I'm done. Thank you for your attention.
Thank you, Batyr. This was a very informative, very well structured talk. I believe our participants can well have some questions to ask regarding especially the last slide. I think it was very metaphorically, very, there is a lot to really discuss. And I think we can take a couple of questions now pertaining to the Russian constitution part that we have. You can ask all of the speakers who just talked. So you can also address your question to either Pavel, Yuri, or Batyr. So please, if anybody wants to ask a question, this is the time to do it now. Especially from the non-speakers of ours. No questions at this time.
Can I
Okay.
ask a question?
Yes.
So my question is to Batyr. So it was a wonderful presentation, and I think what I found very interesting, and I was reading was that, and I also prepared my part on this, that there have been two parts of the Russian constitution, first and the second chapter being the liberal part, and the second part being the authoritarian part, which is the rest of the chapters in the constitution. Now, we have been reading a lot about the Veli Zorkin, and his approach to judicial reviews, and how he considers that rule of law is not essential for the functioning of Russian democracy, because the Russian democracy itself includes authoritarian elements that define the basic core of Russian constitution. So, do you like? Would you suggest, or would you have something to comment on this issue, whether the Russian constitutional courts or other courts, for example, have helped the executive to concentrate more powers and without any checks and balances? Because I was reading about the Mary district judgment where some people were petitioning the court for compensation for destruction of their properties, and it became a massive issue where they were protesting against their livelihood was taken away because of the war. And when they approached the district court in Mary, the court said that the the plaintiff could not explain to the court whether the damage to the property was caused by the Russian forces or the rebellion. So, I mean, in such a situation, do you think that judiciary in Russia has been able to function as it was supposed to be in a democracy, or it has helped the executive to get more political powers or unchecked powers? Thank you.
Thank you. Very interesting question. Not so easy to answer that. First of all, I must say that Russian constitution is a very good example of the fear of the past. In 1990, in theory of constitutional science, we say that in period of evolution or evolution from one type of political system to another, it would be better if we adopt some kind of temporary constitution which allow us to proceed these reforms, these changes, and only after that, when we can understand in which route, in which way will grow our will we build the state and society and legal system, only after that we must adopt the constitution. In 1993, we was afraid that in the period of crisis we must adopt the very best democratic constitution. Is the only way to avoid dissolution Russia as an example of dissolution of Soviet Union. Thus, the first imbalance of our constitution is very democratic by its words, but it's not good for us, especially 25 years ago. But we cannot avoid that. We wrote that we are a democratic state, that we respect a lot of human rights, but we wasn't ready at this time, and I am afraid not ready for 100% at the present time. But we cannot avoid that, unfortunately. So, Mr. Zorkin, and after that, we face it with some problems with, for example, in federative structure of our country. We have 89 Russian regions, and it was very complicated to every question of state management, so on and so forth. And we face it with some kind of unofficial constitutional reforms without changing at very first time, without changing any words in constitution, but we build the federal districts, so on and so forth. And I believe it was inevitable because we need that. And we face it with situation when a lot of Russian legal acts was contradict to constitution. We cannot change constitution because we built this constitutional order and paid very high price. And Mr. Zorkin was in very complicated situation. He must adopt our constitution to the changing our system. It wasn't the very few, it wasn't a very new, because in sometimes slavery wasn't contradict to the Constitution of United States. Racial segregation wasn't contradict to the Constitution of United States. They passed of this Supreme Court of United States also once said that it's not a contradict to human rights, but and after that, American society understands that slavery and racial segregation is not a part of democratic state. Russia faced something similar. And I cannot ask all of parts of your interesting question because it's very complicated, but what I was mentioned, it the way to understanding the current problems of Russian constitution and Russian political system.
Thank you.
Thank you, Batyr. We're now moving on to the Indian part. We're going to talk now about the Indian Constitution. Siddhant, if you have a presentation to share, you can also do it. If not, I'm now giving the floor to you. Please go ahead.
Okay, so basically, when I got to know about this event, I had told Nitish that I would basically be discussing the amendment theories which have been propounded by the Indian Supreme Court and how it has traveled to the world and how I was trying to use it in the Russian context with the latest amendment. So I think Nitish would give you a brief outlook about the constitution, and then I'll just sum it up by concluding on what I feel how Indian Supreme Court judgments have had impact in the other jurisdictions and how Russian constitutional court could have used it to uphold what it had already stated before in some of its judgments. So I think I'll give the floor to Nitish to summarize the constitutional framework, and then I'll just give my concluding remarks on the comparative part of the law.
Thank you, sir. And I would like to thank Batyr, Pavel, and Yuri for their contribution to the discussion. So, the tale of the constitutions, with the emphasis on the amenability of the constitutions. If we talk about the Indian constitution, it's not a tale, it's an epic in itself. So, usually we take almost one full academic year to discuss the constitutional scheme and the amenability, because there are many facets which are connected to the amenability, the amendments to the constitutions. But since we have paucity of time, I'd like to conclude it in the next 10-12 minutes. So, since we have many international participants, it's better to have a brief background as to how did the constitution come and what scheme, with what scheme did the constitution come. So, after 1200 years of foreign attacks, foreign rule, everything, the democracy was finally achieved on 15th August 1947. The British rule ended and the cost was partition. And now we see different countries, Pakistan, Bangladesh. Bangladesh was East Pakistan initially till 1971. It was all a single nation before 1947. And when in 1947 we got the freedom from the British, the constitution making was already in process. The Constituent Assembly assembled for the first time on 6th of December 1946. And this process continued till 26th of November 1949. So almost 3 years, two years, 11 months it went on. And finally, the Constituent Assembly also referred to the constitutions of many other jurisdictions. For example, the parliamentary democracy, the system of parliamentary democracy was taken from British. The concept of fundamental rights were taken from the US. Directive principles of state policies from Ireland. The idea of having a preamble, that was taken from the French Constitution. The lists what power would lie with the union, what power would lie with the federal units would be, it was taken from Australia. Emergency provisions were taken from Germany. And the canvas of all this was the 1935 Government of India Act. Plus, there were the experiences of the Constituent Assembly members, which they interacted with the masses throughout the struggle. And a progressive constitution was finally enforced on 26th January 1950. Now, the term progressive is not used merely as a rhetoric. It was indeed having elements of progressiveness. For example, it started, the constitution, the very first instance said universal adult franchise. Everybody will be eligible to cast vote to choose their government. It was a progressive step. Even in US, in UK, in major developed first world countries, there were debates whether everyone should have the right to vote or not. In fact, Winston Churchill said that giving democracy is like giving country to the dogs in India. But this democracy thrived. And voting rights were also given to the women community. Women community was fighting throughout the globe for the voting rights. But not only the voting rights, but special provision under Article 15, Clause 3 were given to the women community so that special laws can be made for them. The second aspect was human rights. At the very first stroke, the slavery and untouchability was removed. As Batyr also touched upon this, that Constitution of the US, they did endorse, in a sense, slavery. The US Constitution was enforced in 1787, and even after 70 years of the enforcement of US Constitution, in 1857, there was one very interesting case. That was Dred Scott versus Sanford. where the Supreme Court endorsed that no citizenship rights will be with the black community, and slavery is allowed, and slaves would be like property to their masters. But in the Indian constitution, not only untouchability, but slavery was also abolished. And third thing, while the world was getting polarized, getting divided into two lines, inter alia on the lines of ownership, Constitution of India gave a fundamental right to property. And this right to property became a phenomenon, a point of intense discussion and courtroom arguments on the scope of amenability of the Constitution. And it was the journey of finding the soul of the Indian Constitution. In Indian Constitution, basically, there are three methods to amend the Constitution. One is by simple majority, by one half of the members of Parliament, they can amend the Constitution. These are regular matters like salary of the president and all. The second is the special majority by the two-third members. And the third is special majority plus ratification by one half of the federal units. So these are the amendments which affect not only the federation but the federal units itself. Um, Now, the very first amendment came in the very first year of the constitution. Unlike many other constitutions which have very limited number of amendments, India has undergone more than 100 amendments in last 70 years. So very first amendment, the background of this amendment is that under one state's land redistribution act, one zamindar who was the landowner was there, and his land was acquired by the state at very nominal rates. He challenged it, and the court held yes, he has a right to property. So you cannot take it without providing just compensation, and he has the right to property. He can deny it also. Now it was very difficult for the state to bring forward the land redistributions. So the First Amendment was brought. It brought a qualification to the right to life. It said that land can be acquired by the state for a public purpose and for just compensation. And a very interesting element was added to the Indian Constitution. That was Schedule 9. Schedule 9 was a shield. According to Schedule 9, you enact any law and put it in the schedule, it would be out of the purview of the Indian judiciary. It could not be challenged in the courts of law. And this, after this first amendment, this was challenged, and amendment was upheld by the Supreme Court. Said yes, you can amend anything, and anything includes the fundamental rights. Now the tussle started. There were n number of amendments coming up, and mostly there were amendments related to social reform. Some were there to bring forward the political visions, political agendas, or to further the directive principles of state policy. Then came the year when it was challenged in Supreme Court in the case of Golaknath. Golaknath, there were three judges who said yes, you can amend anything. But there were two judges who were the dissenters. So in Indian Supreme Court, judges write individually, unlike many other jurisdictions where they write as a single unit, as a single court. In India, the judges can write their individual views, so there can be dissents. Two judges said, one was Justice Hidayatullah, who went on to become the Vice President of India. He said that fundamental rights are so fundamental that they cannot be amended. While there was another judge, Justice Mudholkar, he said fundamental rights can be amended, but there is something even more fundamental in the Constitution, and that cannot be amended. These two decisions became a ground for the constitutional future of India. While Justice Hidayatullah's, that was Sajjan Singh case, that was Sajjan Singh case. In Golaknath, Justice Hidayatullah's view were endorsed, and it was held that no part of fundamental right, Part 3 of the Constitution, can be amended. Now, this shook the executive and the legislature because they wanted to bring forward certain reforms, they wanted to bring certain changes in the constitution, but they were not allowed to. And very interesting question was put forward by the Chief Justice while holding this. Chief Justice Subbarao said 368 provides for the procedure to amend the constitution, but where is the power? So that was a question, and it shook the executive. They tried every way possible. They tried to elevate their favorable judges to overrule Golaknath. And then finally came 1973, when the landmark case of Keshwananda Bharti. It's a very long judgment, a landmark judgment. Keshwananda Bharti came, and in Keshwananda Bharti, 24th and 25th Amendment were challenged. It was argued whether Parliament can amend fundamental rights, some portion of it, or not. The decision was 7-6. There were 13 judges on the bench to decide the matter. And with 7-6, the court held and endorsed Justice Mudholkar's view that fundamental rights can be amended, but there is something in the constitution that cannot be amended. And that something basic was called as the basic structure of the constitution. Now, what is the basic structure of the constitution of India? While the Chief Justice, Justice Sikri, enlisted certain elements like federalism, supremacy of constitution, republic and democratic form of government, secular character of the government, of the constitution, but there was a judge who played a pivotal role in this judgment. He was Justice Hansraj Khanna, Justice H.R. Khanna. He was pivotal because the bench was divided 6-6, and upon his decision, the whole case would have turned. And he held there's something very basic, but it's like the soul of the constitution. And soul manifests itself differently in different forms, in different scenarios. So it will depend upon case to case whether this is part of basic structure or not. Hence, the basic structure doctrine was established. It's true even today, it's applicable even today. But there was a slight eclipse on it. That was in the year 1975, from the year 1975, when national emergency was invoked in India. The democratic process was suspended, and there was one 42nd amendment to the constitution that was brought. According to the 42nd amendment, among many other things, the 368 was amended, and it said that whatever has been ruled by the judiciary, whatever overturning has been done by the judiciary, that will be restored, and the parliament can amend any part of the constitution. And after, beyond that, there was another amendment in this particular 42nd amendment, which the words socialism, amongst others, that was secularism, word socialism, and part 4 of the constitution, fundamental duties. These two things were taken from the from the USSR, while USSR constitution, and were inserted in the Indian constitution, and that remains in the Indian constitution even today. That 42nd amendment was overturned by the 44th amendment, which was brought by the new government after the emergency was lifted. And the basic structure doctrine of Keshwananda Bharati was restored. And that stands true even till today, with some other terminologies coming up, like the basic identity of the constitution, the constitutional moralities. These are some terminologies which are popping up these days, which I believe Siddhant would be taking note of. So this was the basic overview of the scheme of the Indian Constitution, the scheme of the amenability of the Constitution. And now I would like to request Siddharth to take over and elaborate upon the comparative analysis of the constitutional schemes and the amendment. And he will also be focusing on the recent Russian amendment. Over to you.
Thank you, Nitish, for the brief outlook of the Indian Constitution for the viewers from Russia. And I would just take forward what Nitish said. So when we look at the constitutional structure of India, we in the beginning had certain amendments which were challenged before the Supreme Court, and they were challenged because they were violative of fundamental rights, which could not be amended through a law. And so when the first amendment was introduced in the Constitution that took away the right of property, which was a fundamental right then, it was challenged before the Supreme Court, and the Supreme Court took a view that in the terms of Indian Constitution, only a law passed by Parliament can be challenged as violative of the fundamental rights, and the amendment to the Constitution is always a constitutional law, which is not a law in terms of Article 13 and in terms of what the law should mean. So this is the way how the constitutional cases progress. And the first time in 1973, the case of Keshan Bharati case, the Supreme Court came up with the theory that there are certain basic features of the Constitution that cannot be taken away by any amendment, because the role of the Constitution itself is to limit the power of the executive, of the Parliament and the judiciary. And since the Parliament is a creation of the Constitution itself, the Parliament cannot do anything in order to change the very structure of the Constitution itself, that its identity is replaced and a new one is put in its place. So this was the theory that was introduced by the Indian Supreme Court in 1973. And since then, it has been either accepted in some jurisdiction and it has been rejected by some jurisdictions. But one thing that have been constant, that the courts have actually used this theory to identify their power to judicially review the amendments. So for example, recently when we saw that in 2020, Russian constitution had this provision under Article 81, which said that a president could not be appointed more than 2 times in a row, which meant that a president can stand for election for 2 terms, but to stand for a third election, he has to have a gap. So we saw that after Putin came into the picture, Putin would be elected for 2 presidential terms, and then a new one would be the prime minister. Then he would become the prime minister, and some other person, Madovich, would become the president. So we saw this is how the Russian constitution was allowing President Putin to continue to be at the helm, despite there was a strict requirement under the law, that under the constitution, that there was an intent against the confiscation of power when the constitution was adopted in 1993. So as Batyr introduced, that the Russian constitution contains 2 parts, which is the first part, which talks about fundamental rights, human rights, and the nature of the state, that reflects very liberal values. And when we talk about the other part, which is the next 8 chapters, those 8 chapters talk about, or they reflect a very authoritarian idea of the governance. So I was reading about how in 1998, the first president, Boris Yeltsin, wanted to run for the third tenure as the president. And when he moved ahead and he wanted to pass that amendment, the Russian Constitutional Court said that any move to come or to run for a third election in a row would be violative of the republican form of the government, republican nature of the state, which is recognized as a fundamental feature of the Russian constitution. I say this, it's a fundamental feature of the Russian constitution because Chapter 9 of the Russian constitution talks about that though the Federal Assembly would have the right to make amendments to the constitution, but in order to amend any part of Chapter 1, Chapter 2, and Chapter 9 would require the constitution of a constituent assembly that would make any amendment to a provision which is under Chapter 1, 2, and 9. So when I was doing my research about Russia, I found out that in 2002 there was a judgment where the Russian Constitution Court had itself suggested that rotation of power is a fundamental feature of the Republican form of government. And when this amendment in 2020 by Putin was introduced, this was one of the major arguments which were used by the opponents of the amendment, that if you allow such an amendment to take place, that is in complete violation of the rulings of the Constitutional Court, which has declared that uh, republican nature of government means there should be rotation of power. So now when Putin has already continued for in the presidential post for 2 terms, if this amendment is introduced, then he would be there as the president till 2036, which is very problematic, because what the Russian court have said before was already reflected in Colombian constitutional court judgment, as well as Benin and some other courts. Colombian Constitutional Court and Benin Constitutional Court have previously held that republican form of government means there should be change of rulers, because if you have only one person to be ruling for number of years without any change in the governance, that take away the right of another person to be appointed, which is rotation of power recognized by the Russian Constitutional Court, as well as the problem of separation of power, because there would be one person who will be appointing all the persons required to keep a check on him. So when you have a person who is electing and choosing the offices who are going to put a check on him, that itself means that the regime is authoritarian. So been as Batyr has mentioned before, that it's very difficult to understand the Russian constitutional functioning. But when a constitutional principle has already been accepted in the Russian constitution, then is then any violation of its terms would constitute a violation of the constitution itself. So this was my view on this recent amendment, that in view of its own judgments, the Russian Constitutional Court have neglected the duty. And even when you look at what this amendment would do, this amendment would put a person in power which is going to be there in power till the rest of his life, which is also very problematic. But like I had mentioned before, it's very difficult to understand the Russian system, where the Constitutional Supreme Court, the Chief Justice of the Russian Constitutional Court itself says that rule of law is something alien to the constitutional structure. You cannot look at the outside values, because the Russian constitution is very different and it recognizes authoritarian elements to be more basic than rule of law. So, so when you look at how Indian jurisprudence has traveled in different countries and have led different courts to say republican form of government would include that there should be an express intent against the consolidation of power. The same ruling could have been used in Russia, but it has not been done, which means that there is a tendency where Russia could be used by other countries to say that the constitutional court gives a right to the. And one more thing, that something that I find to be, that when I was reading the judgment, the Russian Constitutional Court judgment, I was I was of the view that the court have suggested something that necessarily does not mean that it's a constitutional problem, because every judgment is susceptible to criticism, and as well as there are points that needs to be taken into consideration. So when I was reading the judgment, I was of the view that the court have said that parliament is the one that makes laws. So Russian constitution gives two choices to the parliament, either to include more restriction on reappointment or let the people decide whether they want the leader to continue. So in this case, the court said that since the parliament has chosen to allow people to choose its leader or reject its leader, But to say that Putin cannot stand for election in view of this current amendment, that would disallow people to make a choice, which is a necessity and a basic feature of a constitutional morality and a constitutional democracy. So, like this like more than this. I think I've always wondered, when you look at other jurisdictions, such amendments have been brought down and such amendments have been declared unconstitutional. But when you look at Russia, these amendments were found to be fine. So I would just like to ask my Russian colleagues from Russia or anybody who can comment, why would court accept such a view, and why would court allow such an amendment despite there being so much of protest, not just within the country and outside. I think I'm done. I think this is what I had to speak about this more.
Thank you very much, Nitish, Siddhant. I think that perhaps the Indian part of the conversation was a little bit more detailed because I did not ask the Russian speakers to focus on the amendability or, for instance, the issue of the abolishment of the liberation of peasants. I think this kind of history of Russia really has a huge impact on psychology of our citizens by today. So, for instance, Marius asked a question about how often we refer to the constitution, how important constitution is to the Russian citizens. This is actually a very crucial question, and I really hope our forum will be more interdisciplinary, precisely because we cannot just talk about law without talking about social psychology and other issues. So I would suggest that if anybody has a question to our speakers, we take the question. Marius, you can turn your mic on and then just ask a question if it's convenient for you.
Okay. Do you listen to me?
Yes, we can hear you.
Hello. My question is about Indian Constitution. You see, I'm a lawyer, and reading a bit this Constitution, I see it's not just a Constitution, but also it has a good nature of administrative code. It's not just Constitution, but also administrative legislation. Why this solution? It's useful or not? Why and if it's useful or not? Thank you. I will write also.
Can I answer? I think we have administrative code for a reason, that we have a lot of because of the administration, because if you look at the structure, we have most, because we are a state with 28 states. In every state there are courts which are there.
There was a connection. Yeah, Nitish, I think you can take over.
No, he has
Okay.
So your mic is off.
Can you hear me now?
Yes.
So I just to understand the relevance of this question, I mean, we have a lot of administrative code because there is so much of litigation that we cannot overburden our courts with too much of litigation. So just for dispensation and for decentralization of work, we have more administrative court, and those administrative courts have also the power to review your administrative orders in relation to its violation of the fundamental rights or other legal rights that a person claims have been violated by any administrative force. I'm so happy that we are joined by Mohan sir. Mohan sir is a Supreme Court senior advocate. I'm so happy, sir, that you have joined us. And Mohan sir has also worked in most of the important constitutional cases. So I just want to thank him for joining this session, sir. Thank you for coming.
I think we have another question in the chat.
Just adding to what Siddharth ji said, maybe because you also referred to something like the past and we learn from the past. Maybe this question has a bit of answer in our past also. So the colonizers, the outsiders, initially came as the traders and then settled as the administrators. And it's a country with vast population and vast administration which is going on. And for example, what are the administrative things which are there in the Indian Constitution? It talks about how the finances would be shared between the union and the states. So, what is the binding force in India? We see many other jurisdictions, they have either ethnicity or religion or some other binding force. In India, it's the constitution which is the binding force, because other elements are so varied that if it is not, constitution doesn't say that these would be the binding forces, the country may disintegrate. And so, let's say finances, if the constitution doesn't say that finances should be distributed in this manner, or elections would be conducted in this manner, this many people will come from a particular state to the they would get reservation, or they come to the central legislative assembly, which is the parliament. So there are chances that the country, one particular set of population which is more influential, may overpower others. So because of this diversity, and to contain this diversity, the constitution makers didn't want to have a very open-ended constitution. They wanted to ensure that the constitution should provide for other things also. And it's not that it has not been a liberal, that if we have provided for everything, there have been no interpretations. There have been n number of interpretations, starting from right to life. What is life? Article 21 of the Indian Constitution provides for life, and it has gone so many amendments. And it is not that because administrative nature of provisions are there in the Indian Constitution, there are no interpretations by the court in the administrative nature. Let's say election, even as uh, a thing like water sharing, the Constitution of India also provides for a water commission, how the states would be sharing the water, because this may also become a issue, and become an issue. In fact, it did become an issue between some states. So the constitution makers wanted to ensure that because of some administrative regulations, the country should not disintegrate. That is why they ensured a proper constitutional mechanism for this.
I think what Nitish just taught us about was a very, very crucial thing, because the role of constitution in Russia, both in terms of administrative terms and in terms of what we do to keep the country together, because as Batyr said, there is a lot reflecting the fears of the past within the Russian constitution, but there are many non-legal mechanisms by which also reflect this fear of disintegration, because I think this fear is very real. But for us, the constitution is not the main mechanism of alleviating that kind of fear. I think Mohan Katarki, if I pronounce the name correctly, you have something to add.
Yes, ma'am. Thank you, madam. I just want to say something, that Indian Constitution is a constitution based on rule of law, and most important thing of the Constitution is that it is an enforceable constitution. If any citizen is aggrieved by non-enforcement of any provision of the Constitution, which he thinks it gives him a right or imposes a duty on the government, then he can approach the court under Article 226 of the Constitution or under Article 32 of the Constitution and seek enforcement of that. That is the distinctive feature of the Constitution of any country which follows rule of law. The Russia, as I have read the Constitution to some extent, and I also traveled in Russia, the main important thing is that you do not have a judiciary which guarantees this right. That makes a difference. I'm not saying belittling the importance of Russia or the system which you inherit. You have your own system. You may not like to have the full rule of law as we have inherited in India. That's a matter of choice the people make in each country. I wish one day you will appreciate and make choice for the rule of law. But at the moment, choice, whatever you have made, that is good for you. But that is the difference what it makes. That is, ours is the enforceable constitution, that every provision of the constitution, if it creates a rights or if it creates a duty on the government, that will be enforced in the court of law. That's what it makes the difference. Thank you, madam.
Thank you very much. I really took note of your remark, and I really think we can elaborate on that in our next discussion, because this is really a very important difference between our two jurisdictions. If Batyr has something to comment on that, you can add something. If not, I believe it's time to wrap up for us. No. Okay, I would like to thank all of the participants of this talk. I believe it was a very good discussion. Nitish, on your part, as also a co-founder of this initiative, I would like to ask you to say a couple of concluding words, please.
I would like to thank everybody for joining, including Mohan sir, a senior advocate in India, and our panelists from Russia, Batyr, Pavel, and Yuri, and my dear friend and senior Siddhant sir. So thank you for joining. We hope that in the future also we have many constructive discussions, and we learn something from other jurisdictions. Today it was India and Russia, but we hope to extend it to other jurisdictions also and have a constructive discussion, not only in law, but other things like philosophy, politics, literature, something like other aspects also. And I would like to thank everybody for joining. Thank you.
Thank you, sir.
Goodbye. Have a nice evening. Bye.
Thank you.